Hello viewers, I am Dr. Shivani Gupta from the University Institute of Legal Studies, Punjab University, Chandigarh. It is my pleasure to welcome you to this session on a not so common topic in the law of property, that is, doctrine of lis pendens, its meaning and significance. In this session, we would learn about the meaning and significance of the doctrine of lis pendens. This session would help the viewers understand the importance of the concept and will be able to make out the situations in which the doctrine would be attracted and will be able to understand the effect of such an application. First of all, let us understand what is the meaning of lis pendens. The doctrine of lis pendens is contained under section 52 of the Transfer of Property Act 1882, which shall now be referred as TPA. The phrase lis pendens is a combination of two Latin words wherein the word lis means litigation and the word pendens means pending, thus connoting the meaning pending litigation. In literal terms, any suit, proceeding, or legal action that is pending in a court of law can be termed as lis pendens. This phrase is associated with the Latin legal maxim pendent lit nihil innovatur pendens, which means nothing new should be introduced during the pendency of litigation. It signifies the concept that when a legal matter is ongoing in a court of law regarding some title or rights that arise thereof in such immovable property, no new transfers must be made to such property till the time the matter is not finalized in the court. It finds its base in the common law principles of justice, equity, and public policy. In the case of Rajendra Singh and others versus Santa Singh and others, 1973, the Honorable Supreme Court cited that lis pendens literally means a pending suit, and the doctrine of lis pendens has been defined as the jurisdiction, power, or control which a court acquires over property involved in a suit pending the continuance of the action and until final judgment therein. Recently, in the case of Shiva Shankara versus H.P. Davaiya-Char 2023, it has been observed that the principle of lis pendens is based on justice, equity, and good conscience, and the same shall be relevant even in cases where Section 52 TPA do not find strict application. Further, the explanation appended to this section clarifies that the pendency of a suit or proceedings shall be deemed to commence from the date of the presentation of the plaint or institution of the proceeding in a court and to continue until the suit or proceeding has been disposed by a final decree or order and complete satisfaction or discharge of such decree or order has been obtained or has become unobtainable by reason of the expiration of any period of limitation. In short, pendency of proceedings or suit would begin on the date of presentation or institution of the plaint in court of competent jurisdiction and would continue till the date the court passes its final decree or order. Now, where did this doctrine origin from? The doctrine of lis pendens finds its origin in English courts in the case of Bellamy versus Sabine, 1857. Let us understand the facts of this case with the help of a simplified illustration. Mr. A sold his immovable estate to Mr. B. A's son, double A, being his heir, sued Mr. B to declare the sale void. When the litigation was pending, Mr. B sold the estate to Mr. C, who did not take notice of the pendency of the suit. Setting aside the sale to Mr. C, the court herein held that AA was entitled to the property. It was also held that Mr. C would not get any title in the property, as he had purchased the property from Mr. B, who himself was not having any clear title in the property at that time, and thus could not convey it to Mr. C. While holding the judgment, the court herein made the observation as this is a doctrine common to law and equity courts, which I apprehend on the grounds that if alienation pendent right was allowed to prevail, it would simply not be possible for an action or suit to be resolved successfully. It was further observed, in any case, the plaintiff will be responsible for the defendant who alienated the property before the judgment or the decree, and must be obliged, according to the same course of action, to initiate these proceedings de novo. This forms the base of the law as contained under Section 52 of TPA. Thus, Section 52 reads as, during the pendency in any court having authority within the limits of India of any suit or proceedings which is not collusive and in which any right to immovable property is directly and specifically in question, the property cannot be transferred or otherwise dealt with by any party to the suit or proceeding so as to affect the rights of any other party thereto under any decree or order which may be made therein, except under the authority of the court and on such terms as it may impose. So, what is the object behind this doctrine? The purpose behind this doctrine is to protect the rights of the parties to the suit by preventing either of the party from transferring the disputed property during the pendency of litigation, so that the transfer does not have the effect of frustrating the ultimate result of the suit. It thus binds the third party with the suit's outcome, if such party had acquired interest in that property during the pendency of suit. The doctrine, by preventing the transfer of a title of any disputed estate, seeks to prevent the onset of endless litigations which will help in bringing a successful termination of the lawsuit. The Judicial Committee of the Privy Council, way back in the case Gauri Dutt Maharaj versus Sheikh Sukur Muhammad 1948, has observed that the broad purpose of Section 52 is to maintain the status quo unaffected by the act of any party to the litigation pending its determination. The applicability of the section cannot depend upon matters of proof or the strength or weaknesses of the case on the one side or the other in bona fide proceedings. To apply any such test is to misconceive the object of the enactment. The Supreme Court, in the case of Ayyaswamy versus Jairam Mudaliar 1973, held that this provision does not intend to deprive the parties of making just and fair arguments, but on the other hand assures that the parties defer to the authority and jurisdiction of the competent court, which is fully capable of satisfying the concerned parties regarding the claims in property, that they have put before it. It was even held in the case of Har Narayan versus Mamchand that any registered transfer as affected under Section 47 of the Registration Act 1908 during the pendency of litigation will not have the effect of vitiating the objectives of Section 52. It was made amply clear that the fiction produced pursuant to Section 47 does not prohibit lis pendens from functioning. For the application of the doctrine of lis pendens, following essentials must be present. First, a pending suit or proceeding. Second, suit must not be collusive. Third, the suit must be pending in a court of competent judicature. Fourth, the suit must relate to some right in immovable property. Fifth, the right to immovable property must be in question either directly or specifically. Sixth, the suit should have the effect of affecting the rights of the other party. Seventh, either of the parties to the suit transfers the property in question. First aspect we will study here is pendency of suit. The doctrine of lis pendens applies during pendency of suit as well as the appeal which finally disposes of the suit, and if the decree is executory until satisfaction of the decree by execution or until execution is time barred. An important case on this point is Kedarnath Lal versus Shio Narayan 1970. In this case, there was a petition for mortgage decree which was filed on April 5, 1934. It is important to note here that the petition was for a mortgage decree. The court carelessly made a money award on August 16, 1934, but later on corrected its own order and passed a final mortgage decree permitting the petitioner to purchase the mortgaged property. The petitioner, since he obtained possession on July 20, 1937, thus it can be said that the petition remained pending from April 5, 1934 to July 20, 1937. So, any transfer of mortgaged property in suit during the period would be hit by the doctrine of lis pendens. It was also held in this case that the doctrine of lis pendens would apply to bona fide proceedings irrespective of the strengths or weaknesses of the case on one side or the other. Let us elaborate on another important verdict with the help of an illustration. This illustration corresponds to the facts of the case as in Koili versus Rajasthan District 2009. The land in question belonged to Mrs. X's husband. After X's death, his brother, despite knowing the fact that Mrs. X was his sole legal heir, filed a lawsuit pursuant to khatedari rights. Following this suit, Mrs. X had to contest the suit as the sole heiress. While the suit was pending before the court of competent judicature, X's brother transferred the land to someone else. Herein, since this transfer was made without court's permission, the transfer was struck down after applying the doctrine of lis pendens. In the latest Supreme Court judgment of Shingara Singh versus Diljit Singh 2024, it has been reiterated that once a transaction is found to be hit by the doctrine of lis pendens, then the defenses of being a bona fide purchaser and lack of notice regarding the sale are not available. In the case of Siddham Setti Infra Projects Private Limited versus Katta Sujatha Reddy 2024, the Honorable Supreme Court has declared that the doctrine of lis pendens kicks in or commences at the stage of institution and not at the stage when notice is issued by the court. It further elaborated that Section 52 of the Transfer of Property Act would apply to the third party purchaser once the sale was executed after the review petition was instituted before the court. Any transfer that is made during the pendency is subject to the final result of the litigation. Next important aspect to understand is that the suit must not be collusive. The doctrine of lis pendens will neither apply to a collusive suit nor to a suit in which the decree is obtained by fraud or collusion. A leading case law on this aspect is Nagu Bai Amal versus B. Shama Rao 1956. The Supreme Court in this case held that collusion is a secret arrangement between two persons to obtain a decision of a judicial tribunal for a sinister purpose. The court in the same case also differentiated between collusive and fraudulent suits in the following words. In collusive proceedings, a claim put forward is fictitious. The contest over it is unreal, and the decree passed therein is a mere mask having the similitude of a judicial determination and won by the parties with the object of confounding third parties. But when a proceeding is alleged to be fraudulent, what is meant that the claim made therein is untrue, but the claimant has managed to obtain the verdict of the court in his favor and against his opponent by practicing fraud on the court. While in a collusive proceeding, the contest is a mere sham. In a fraudulent suit, it is real and earnest. Next aspect is that it must be in a court of competent judicature. The doctrine will have no application unless the suit is instituted in a court that have competent jurisdiction. Under the Code of Civil Procedure, there are many things that decide the competency of the court. The appropriateness of jurisdiction may depend upon the territorial limits of the court, what we understand as territorial jurisdiction, on the basis of subject matter of dispute, what is called as subject matter jurisdiction, or on the basis of valuation of the disputed matter, that is pecuniary jurisdiction. In pecuniary matters, a suit in a court of higher pecuniary jurisdiction shall be treated to be won in a court of competent jurisdiction. Even the supervisory jurisdiction of the court under Article 226 and 227 of the Constitution attract the application of this doctrine. The doctrine, however, does not come into operation on the mere presentation of the plaint. It becomes applicable when the plaint is presented in the court of appropriate judicature along with proper court fee. If a plaint is not accepted but rejected by the court for faults, the plaint shall not be deemed to have been instituted. Thus, the doctrine will not come into operation. Another aspect is involvement of direct or specific right in immovable property. Merely the fact that some immovable property was mentioned in a pending suit before the court would not attract the application of the doctrine of lis pendens. For instance, where a suit was filed by a Hindu widow against her stepson, merely mentioning that she was in possession of some immovable property would not attract the doctrine because it would not suffice the requirement of direct or specific involvement of immovable property in the pending suit. Over the passage of years, the courts have laid down that suits for partition, suits for mortgage, easementary suits, suits for preemption shall be considered as suits that involve the direct and specific involvement of immovable property. Another concept is void transfers under lis pendens. In the case of Samarendra Nath Sinha versus Krishna Kumar Nag, 1966, it was held by the Supreme Court that the result of the litigation must bind the party to it. So, in the same manner, it must bind the person deriving his right, title, or interest. During the pendency of any suit regarding an immovable property, if any interest is transferred by any party to the suit, such a transfer stands void against the person acquiring interest in that property under the decree or final order from that suit or proceeding. In other words, a transfer against a subsequent transferee from the date of the institution of the suit is void. Let us try to understand this with the help of a simplified illustration. There is a suit pending between Mr. A and Mr. B regarding title in the property X. During the pendency of the suit, Mr. A transferred the property under dispute to his daughter. After 6 months, the court gives its decision in favor of Mr. B. According to this rule, now A's daughter cannot claim any interest in the property that was so transferred to her pending litigation because such transfer is void. It is important here to be clear on the aspect of a void sale and a void transfer. In the case of Hardev Singh versus Gurmail Singh, 2000, the court has ruled that this provision does not make the sale of the contested property either void or unlawful, but only puts the rights of the subsequent purchaser beyond the binding limits of the judgment in the case that decides upon the nature of the conflict. Now we shall study what are the exceptions to the application of this rule. First is where the property has been transferred under the application of some law. The Allahabad High Court in the case of Rajaram versus State of Uttar Pradesh 1983 held that if the state made the transfer in the exercise of its statutory power, section 52 of Transfer of Property Act would have no application. It would only apply to transfers made voluntarily. Similarly, the devolution in the official receiver is a devolution by law, not attracting the application of this rule. Second is, property may be transferred by a party to the suit pending litigation where the court so permits on such terms and conditions as the court may deem fit. It is a settled principle of law that a transferee pendent light is bound by the verdict of the competent court. Such a transfer is subservient to the decision of the court and is applicable on him as if he was himself a party to the ongoing suit. Third is where the suit is not regarding title or interest in immovable property. For instance, A owns a shop which he has rented to B. A suit is pending between them regarding the payment of rent. During the pendency of this suit, A sells the shop to C for consideration. This transfer is not affected in any manner by the doctrine of lis pendens because the suit was not regarding the title or interest of immovable property, but was only regarding the payment of rents. Another aspect is where the property is sold in auction or in execution of a different court decree. Another point is sales may be allowed through private negotiations, but such sales or transfers would be bound by the decision of the competent court in which the litigation is pending. Another aspect is where the property, because of lacunas in its description, cannot be correctly identified. And the last point is where the court, under Order 21, Rule 63 of the Code of Civil Procedure, orders restoration of immovable property. Thus, to conclude, it can be said that the doctrine is only applicable on a property being transferred that is directly and substantially involved in a suit which is pending before a court. Thus, merely mentioning an immovable property in a court proceeding would not attract this doctrine. It prohibits the transfer of property during the pendency of suit, but does not invalidate any such transfer, though the ultimate effect would be that the transferee would be bound by the decision of the court, thus making his interest in the property contingent depending upon the verdict of the court. This doctrine is completely based upon the common law principles of justice, equity, and good conscience. It, however, gives more prominence to the concept of necessity rather notice to the subsequent buyer. It is a concept which strives to protect justice to all without affecting the rights of either party to the suit. In totality, the ultimate object of the doctrine of lis pendens is not to invalidate the subsequent transfer, but to actually make it subject to the result of the litigation. That was all for now. Thank you for watching.